Today is the deadline for filing amicus briefs in the U.S. Supreme Court case of Hollingsworth versus Perry. It's another milestone in a long fight for equal marriage rights in California. This morning, I, along with 22 prominent professors from all over the nation, have filed an amicus brief in Hollingsworth versus Perry, focusing on rights taken away by Proposition 8 that are of importance to all Californians and are uniquely affect our state legislature. Proposition 8 eliminated more than just equal rights to marry. Proposition 8 also eliminated the ability of those seeking equal marriage rights to pursue those rights through their elected representatives. That deprived a historically disadvantaged group, a group which I am a member of access to traditional representation in a representative democracy. And that deprivation violates the Constitution. Let me be clear. If a voter initiative can deny gay people access to traditional representative democratic processes, then in California, any other small, historically disadvantaged minority group can also be denied the right of representation. Proposition 8 clearly inhibits my legislative role, preventing me and my peers from moving forward legislation on marriage equality, although clearly we would like to do so if we were allowed. Further, if a constituent requests that I or one of my elected colleagues pursue marriage equality legislation, none of us would be able to see such a bill signed into law due to the restrictions placed upon us by Proposition 8. So in addition to the damage Proposition 8 does to same-sex couples and families, it also warps the state system of checks and balances so that the only power to seek equal rights is through the courts or via an expensive, unwieldy, and easily manipulated initiative process. Even though the latest field poll shows record support for same-sex marriage, gay people have had their rights voted on more than any other group. We've been targeted by initiatives more than any other group. We've had our rights taken away in the representative democratic process, and we are left only with the initiative process, rolling the dice in an expensive and easily manipulated process. In fact, the framers of the Constitution regularly cited the protections of the rights of minorities as a justification for representative democracy. In Federalist 51, James Madison asserted that the value of guarding, quote, one part of society against the injustice of another part, end quote. We're urging the court to remember this important issue when they consider the toxic effects of Proposition 8.